Okay, I got to add one more sentence to this. Your Honor, you have no clue to what I've put together. I've worked on this since the motion for summary judgment came back. It rechanged the picture. So I worked for the writ of mandamus on due process. And unless you see what I have, you have no clue what I've got. You're just saying, no, I'm not going to do it no matter what. And that is not what due process is about. So I and if you take that personally, I apologize.
I don't know if our microphone's on. Start video.
I can hear you.
Oh, okay, good.
Okay, there we go. Mr. Cochran?
Yes, sir.
And then who else? We're looking at one other person on the phone.
David Goad, G-O-A-D, Your Honor.
Okay, Mr. Goad. Okay. This is Judge Eric Shepard presiding in Travis County Court at Law number 2, and I'm calling this hearing to order in cause number C1CV 23004-122, Dean Smith versus David Goad. The date is Thursday, November 9, 2023. This hearing is being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted other than by the official court reporter. Any violations of these instructions are punishable by contempt of court. If you would announce yourself for the record, tell me who you represent and whether you're the movement or respondent in today's hearing.
My name is Steve Cochran, and I'm representing Dean Smith, the plaintiff.
All right.
I'm Dean Smith, the plaintiff.
And Mr. Goad, you're here via phone only?
Respondent.
Okay. If everybody who's testifying today will raise the right hand, including Mr. Goad, you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Cochran.
Yes, sir. So
Go ahead.
Okay. I'd like to call plaintiff Dean Smith. Would you please state your full name?
My name is Dean R. Smith,
Your residence address,
415 Lane.
and how do you make a living? What do you do?
I'm head of sales for a home builder here in town.
In New Braunfels? Or?
No,
Sure.
in Spring Branch.
Gotcha.
Already.
Am I correct that you purchased property to find that property?
Through the court listings, foreclosure properties coming available.
Did you attend the sale?
I did attend the sale.
And was there any starting bid that the bank wanted?
Yeah, the opening bid was approximately $217,000.
Were there any other bidders?
There was another bidder, a realtor out in, I think, San Marcos. Yes,
Did you end up with the highest bid?
I did.
How much was that?
$256,000.
Let me show you what's been marked as Exhibit 4, and I'd ask you to identify that, please.
That is correct. That's the deed of trust.
That's your
Yeah.
foreclosure sale deed
Yes,
that you received. Not sure when that was dated. The sale was on May 2nd, right?
correct.
Okay. And did you, after buying the property, check to determine whether the property was occupied?
Yes, I drove by, looked like it was occupied. And then
So did you contact our firm for representation?
I did. When I realized it was occupied, I contacted you to
All right.
start the process.
And then you agreed to pay our firm $275 an hour for legal work in the case?
I did.
Did you ask me to send a notice to vacate to the occupant, Mr. Goad?
Yes, sir, I did.
I'll have you look at Exhibit 4, and is that the notice that you asked me to send?
That is
And that was dated May 16,
correct.
2023. And Judge, that did include a statement that Mr. Goad might be adjudged attorney's fees.
This is Exhibit 2 or Exhibit 1?
I'm sorry, I'm actually starting with 4.
Okay, 4 is the foreclosure sale document.
It is, Your Honor.
Did you were you offering that into evidence?
Did what? I'm sorry?
Were you offering that into evidence?
Yes, I thought I'd do them all at once, but yes.
Oh, okay, that's fine. If you want to do them all at once, that's fine.
Okay. I appreciate that, James. Thanks. So Exhibit 5 is the notice to vacate. And then let me ask you if you filed an eviction petition in a JP court in
I
Comal
did.
County.
On May 31st, I filed the eviction and had a court date set of June 20th.
All right. And is that Exhibit 6? Is that the petition that you filed?
That is.
Okay. And that was filed on May 31st, right?
That is correct.
So Mr. Goad had about 14 days notice to vacate before you filed your petition.
Correct.
Okay. All right. And you and I attended the hearing on June 26th, and am I correct? You recovered a judgment for possession and for attorney's fees?
I did.
And did you receive notice from Mr. Goad, it's dated July 3rd, that he had appealed the case to county court?
I did.
What were your plans for the property after purchasing it?
The plans was to turn it into a rental.
Are you familiar with rental values in Comal County and New Braunfels?
I am. I currently own 4 rentals in the Comal County and 2 in Bear County, so I'm familiar with rentals.
And you're also a sales professional, although you don't deal in used homes.
Correct. I only deal with new homes.
All right. Do you have an opinion as the owner of the property on the reasonable rental value of the property?
I do.
How did you arrive at that opinion?
I did some research on the neighborhood. There are 3 properties in the community, 2 that are currently rented and 1 that is on the market available to be rented.
So what did you do in terms of calculating? If you
So
did?
the 2 that are rented, 938 Lakefront and 963 River Rock, both rented for approximately $2,400. One was $2,400, one was $2,395. They're a little bit smaller house, so I'm doing the research determining, but they were closer to the park area, but considered them comparable properties in the neighborhood. There's a 3rd one that was currently on the market. I apologize, I didn't check today if it still is, but that's 911 River Hill. It is a larger property. It's on the market for $2,850 a month, but I see this property being a little bit less than that because it's not as large of a property. It's 1 less bedroom, but the property 1154 River Tree that I purchased is a little bit better location, even though the other one is across the street because the other one backs to a commercial property.
So you looked at the comparable properties and then made adjustments to arrive at your opinion?
I did.
Is that correct?
Yes.
Based on your research, what is your opinion on the reasonable monthly rental value of 1154 River Tree?
I believe it's reasonably to get $2,400 a month.
And the appeal from JP Court to County Court has now taken right at 4 months.
Correct.
Is that correct? And are you asking the court to award you 4 months of lost rentals?
I am, yes, sir.
And what would that come to based on your opinion of the rental value?
At $2,400 a month, 4 months, that'd be $9,600.
And are you also requesting the court in this case to award you possession of the property and attorney's fees?
I am. Yes.
Judge, I'd like to enter into evidence Exhibit 4, 5, and 6, and then also Exhibit 1, which is the home equity security agreement, basically a deed of trust for the property. It's a certified copy signed by Mr. Goad. And the relevance of that exhibit is on page 15, the 2nd paragraph, the 3rd paragraph in section 22, which I believe I highlighted on the court's copy, which states, if the property is sold pursuant to this section 22, borrower or any person holding possession of the property shall immediately surrender possession to the purchaser at the sale. If possession is not surrendered, borrower or such person shall be a tenant at sufferance and may be removed by writ of possession or other court proceeding. I'd ask that Exhibit 1 be admitted into evidence.
Repeat,
Mr. Goad,
where is that located?
It's Exhibit 1,
page 15.
Page
Mr.
15.
Mr. Goode, any objections to exhibits 1, 4, 5, or 6?
Just a moment, sir. I apparently have the trial exhibit wrong one here. I have 1 through 5. I don't see a 6. Here we go. Here's the new one. Okay, I apologize. I was looking for the wrong one. Just a second. We got exhibits 1, 4, 5, and 6 are being admitted. That's the ones, correct?
Those are the correct, yes.
And page 15 on exhibit 1.
Yes, sir.
Sold pursuant to foreclosure, correct?
Yes.
Okay, I've got that. And the foreclosure deed is for notice to vacate dated, yes. I'm going to make some objections here, Your Honor, but just please take in consideration that I'm 1,300 miles away. That's why I couldn't get online. I came out here to see a doctor and a cardiologist because my issues have become much worse, and I'm trying to get off this medication. I'm having some severe problems in memory. I can reach to grab a piece of paper to make a note and forget what I'm writing down. So I'm going to go kind of slow here. I apologize. So let me get these separated out of here. All right. I'm going to object to my objection to number 1 is the word foreclosure. The Constitution of Texas, I think it's 50 AB something, whatever it is, I do have it here, requires a procedure for foreclosure which has never been met. The due process, which we're going to go into later, there's been no due process of foreclosure by the Constitution of Texas. There was a 736 hearing, which I was not privy to. There was an order signed to foreclose on the property the day before the scheduled hearing. I had a verified complaint regarding falsified documents, false transfers, fraud, deception. The court has a copy, but not in its. I believe that everything was forwarded up there, but I have to say the internet went down about 3 o'clock yesterday afternoon. I spent 2 hours trying to get it operational. I work off of just a second here.
So that's your objection to
words,
exhibit 1?
Sir?
This is your
part
objection.
of the objection, but I'm leading to why I did not get my evidence before the court yesterday. All right. So let's go back to this. The property was not foreclosed upon in accordance with the Texas Constitution, nor was it foreclosed upon under the United States Constitution, 14th Amendment of due process. So I object to that because the foreclosure did not take place according to Texas law or the United States Constitution. It did not take place.
That objection is overruled and the document is admitted.
Okay, now number 4, foreclosure sale deed from Deutsche Bank. I'm going to object to that. And the information there is Deutsche Bank had no standing. There, in the last motion I placed before the court, it shows that the bankruptcy, the appointed bankruptcy trustee for the court in either Delaware or I believe it was Delaware, I provided a copy there, claimed that under oath, the original loan from New Century Mortgage was transferred to Barclays Bank before the bankruptcy. And I also produced evidence that Deutsche Bank has committed fraud in Florida, and I showed the case during the same time as mine where they were moving these loans away from the bankruptcy court. All I can say is it smells like bankruptcy fraud. Moreover, in the documents that he has submitted with the deeds, and it's in here, they're falsified. The chain of title is completely broken in his own exhibits, and it has not been mended. That is an area of law I have expertise and actually taught law on that subject matter to over 200 attorneys and engineers in the state of California back in the 80s. The chain of title is broken. The title and the Deutsche Bank had no standing to transfer that deed to him. So that deed is invalid. And the documents, I would have sent a new fresh set of documents, but the JP court claimed they sent you a complete copy of everything. So the court does have that. Number 5.
Okay, well, let's go. Well, that's number 4. I will overrule the objection with regard to 4. 4 is admitted.
Okay, notice to vacate dated May 26th. I don't recall ever seeing this notice to vacate. The notice to vacate was a handwritten notice provided by, and I'd like to cross-examine the witness here, and I can prove the notice to vacate was provided by Mr. Smith's representative, I believe, a real estate agent. The court has a copy. It was handwritten. It was placed on my door, and it was placed during the pendency of a bankruptcy case, which is null and void. No action can be taken during the time of which a bankruptcy is in progress. And it was. This other 3-day notice, I don't know. I don't have a copy other than plaintiff's trial exhibits.
All right, well, let's hold on. Wait a minute. Hold on. Mr. Cochran, would you like to address those points, please?
Yes. First of all, Mr. Gode's bankruptcy was dismissed, I believe, on June 14th, summarily dismissed. Yes, my client did have a coworker
Realtor.
post the notice.
Yeah.
When he hired me, I said,
Posted where and how?
on the front door.
So there was a notice posted on the front door. And
In an
then
envelope?
No, Judge, it didn't comply with the property code. So when
that's why I hired.
Mr. Smith hired me, I said, no, we've got to do a proper notice, certified mail, return receipt requested. And as you can see, and the exhibit has attachments from the post office saying we left 2 notices to come get your certified mail.
So it was sent certified mail to him, and notices were left to come get the certified mail.
Right, yes.
And that certified mail was this particular deal. All right, then the objections are overruled and 5 is admitted.
Well, may I finish?
I thought you were through.
No, I'm not.
What are your other Mr. Goode? What are your other objections to number 5?
Same objection. The notice is dated May 16th. He just stated the bankruptcy was dismissed on June 14th. I did not receive a copy of this notice until far after. I don't know what date it was posted on the door. It doesn't say here. There was something posted on the door with a tie clip on it, with a strap. Yes,
but they also sent it. They also sent it first. They also sent it by mail. So. Mr. Goode?
Yes.
Mr. Cochran, would you like his?
I don't have a copy. All I know is the process was started during the wrong time. And according to what he just said, this notice was given during the pendency of a bankruptcy. It was done on May 16th. That's the date, his date. And he's
hold on a second. Hold on.
Termination.
Mr. Goode, hold on just a second. Mr. Cochran?
There was no hearing on the eviction during the bankruptcy whatsoever. I told the JP court that bankruptcy had been dismissed. And,
okay, but my question is,
and we never had notice of the bankruptcy, Judge, until we got ready for the JP court. We never had notice. There was no proceeding in bankruptcy court to
you gave him notice that he was about to be evicted, but that notice occurred, and the notice occurred before the bankruptcy was evicted, correct?
Yes, it was dismissed on June 14th.
But no hearing was held no hearing was held.
No hearing was held until
you just gave him notice.
Yes. But the hearing was after the bankruptcy was dismissed. I made that clear to the JP court that we could proceed.
All right.
As I said, there was no we had no knowledge of the bankruptcy. We had no way of knowing that the bankruptcy happened until we got
This is Exhibit 5?
Yes.
Any other objections to Exhibit 5?
Yes, Your Honor. Irrelevant about the hearing. The federal court law, the rules do not say anything about a hearing. They say any process, any procedure, any movement has to be halted until after the bankruptcy. Nothing can be done. The notice is invalid, both notices. The one put on the door, this is invalid. This invalidates this entire case, and he just admitted to it. And the federal court, I don't have any case law on it here, but it's very clear if you look up the notices there, they cannot pursue this. They cannot transfer title from Deutsche to him. He cannot give them money. Deutsche cannot accept money, nothing, zero. It ends, it stops. It's a stop sign. You don't roll through it. It's not a California stop. It is a stop sign. And he admitted to it. This invalidates the entire case because the procedures of due process have not been held. But we've had due process issues since day one for years now, and it just keeps on rolling and rolling and rolling. He just admitted it. This case is invalid, and he has no standing to be in this court.
Okay, hold on. The exhibit is admitted. And
right. The next exhibit,
Mr. Cochran, what were you saying?
No, if the exhibit's admitted, then we're fine. Exhibit 2 is a certified copy of the transfer of lien from the prior mortgage holder to Deutsche Bank, who sold the property.
Exhibit 2?
Exhibit 2 is a transfer of lien, Texas.
Okay, I have admitted 1, I have admitted 4, I've admitted 5, I have not admitted 6, and I hadn't heard anything about Exhibit 2.
Well, I'm presenting that, and it's a certified copy from the deed records in Comal County of the transfer of Mr. Go's lien from a prior mortgage holder to Deutsche Bank, who sold the property at the foreclosure sale. I did that just to have a chain of title there from the foreclosure deed and what transpired prior to that.
Mr. Go, do you have an objection to Exhibit 2?
Exhibit 2?
Yes, sir.
Absolutely. As I stated earlier, these are fraudulent transfers.
Okay.
And the court has
then the exhibit is admitted.
Finally, Judge, Exhibit 3 is the home equity foreclosure order that was required to be obtained by the mortgage holder, Deutsche Bank. And that was pursuant to a lawsuit, actually. It's a Rule 736 proceeding where Mr. Goad was served with that order, and a district judge in Comal County on February 8, 2019 allowed the foreclosure to go forward. And I think the delay in getting that done was 2 years of pandemic and other delays. But I'd like to have Exhibit 3 introduced into evidence as well.
Any objection to Exhibit 3?
Absolutely, but I need to go back to 5 for a moment, sir. The attorney just stated to the court he did not know anything about the bankruptcy. That's untrue in his own documents that were filed with the court, the JP court, in order to get fees. They knew 100% I was in bankruptcy, and that's why they held off. And they actually put in fees for that to recover in the JP court. So let's get honest here, okay? I'm going to go back to 5 again.
Mr. Goad, I've gone back to 5. I've admitted 5. And if what you're telling me is true, then all the documents I've admitted prove the point that you're making. I've admitted 5 because I'd like to see the documents.
You'd like to see
it has nothing to do with what you're making are arguments that prohibit him from winning the case. And that's one thing. But the document itself is, in fact, valid.
Let me address that again, Judge. As I recall, talking to the Deutsch lawyers after the fact, he filed his bankruptcy about 4 o'clock in the afternoon on the date of the sale. The sale was conducted pursuant to Exhibit 4 at 10:05 a.m. We didn't know anything about the bankruptcy.
I did not know. No.
Mr. Smith didn't know. We never got notice of the bankruptcy. If Mr. Goad wanted to fight that, he had an obligation to institute a stay proceeding to stop us from going forward.
I understand that. Mr. Go's objection is to the exhibit. I'm letting in the exhibit if for no other reason than to read the documents he claimed prove up the fact that that's in fact what happened.
That's fine.
So 1, 4, 5, 2, and 3 are all admitted at this point.
All right. There should be 4, 5, and 6 were testified to by.
Yeah, but you didn't offer 6 yet.
Okay, then let me offer Exhibit 6 into evidence.
What's your objection to 6, Mr. Goad? Mr. Goad?
Just a second. I got to look at it.
Okay.
I didn't have 6 on my other one because I had the wrong one here, so I've got to find his 6.
Okay.
It's the eviction petition.
Yeah, I know it's at the here at the end. I just got to find where the first page begins. How many pages are in 6?
2, I believe, or 1.
Well, I'm not finding 6 attached to my it's plaintiff's first amended trial exhibits.
It's
Wait.
it's an amended trial exhibits. It was done after the first set of exhibits.
I have that dated filed 10/23.
It's the eviction petition that you were served with by the JP Court.
Oh, I see Exhibit 6. It only says Exhibit 6 on the top page. Okay, I see why. I was looking for a lead page petition. Is this the original one you filed in the court on 6/20?
Filed on 5/31.
I'm sorry?
Speak up.
It was filed on 5/31.
It says court. Oh, is that court date of the hearing 6/20?
Yes.
Hearing was 6/20.
It was filed May 31st. No.
Which would have been after the bankruptcy was dismissed, correct?
Correct.
Okay, my objection to this is again that even though the case was filed after the bankruptcy, no action. They nowhere in the federal statutes does it state, well, you can do this, but you can't do that. It says stop. You can't do anything.
I understand
so
your
in order to file this eviction case, they have to first give me a proper notice, and they gave that notice during a stop sign. They can't do that.
We didn't get notice.
Mr. Goad, you've made that objection before. I'm cognizant of the objection. It's on the record. I'm admitting the exhibit.
I just want to make sure I do it on this one.
No, everything that you have said since you started talking is on the record.
Sure.
Okay. And so I'm admitting the exhibit because according to you, what the exhibit does is prove that in fact it happened after the date or before the date at a time when you were supposed to be in bankruptcy and they were not supposed to do anything. If you are correct in your assessment, what your argument is, as I understand it, is that all of these things have dates on them that would show that during the bankruptcy, before the bankruptcy was dismissed, in fact, they were doing things that were procedurally incorrect because they're not allowed to do so by the bankruptcy code. Isn't that your argument?
Affirmative.
Thank you. All right, let's go.
Judge, if I can just add, he had an obligation to bring that to the bankruptcy court's attention because Mr. Smith and myself had no notice.
Mr. Goad, stop talking when others are talking, period. That's a stop sign too. Yes, sir.
I just want to state that neither myself nor Mr. Smith had any notice that there was a bankruptcy proceeding pending. And if Mr. Goad wanted to challenge that, he needed at that time to put a stop to any further proceedings in his bankruptcy case. He did not take that action. So we were not subject to any stay because
We mean, you're saying that he didn't, well, as I understand your argument is this, you didn't know, and so any actions you took were done unaware that there was a bankruptcy proceeding. When you, as I understand the rest of your argument, it is once we found out, we stopped the proceedings and did not do anything further. Mr. Goad's position is, if you give me notice when it's supposed to be stopped, then the notice is invalid and therefore the notice you can't give. Your position is, I can't give you, I don't know that the notice is invalid if I'm doing something unaware that in fact you are in fact in a bankruptcy situation, and since you didn't bother to tell us that you were in a bankruptcy situation, that's not my problem. We stopped when we got found out, and the notice is still valid because you knew that the notice was valid, and at least at the documents prove that in fact when it was done and how it was done. And so that's the question for the court. We just need to move on from here.
If I could just add, it was incumbent upon Mr. Goad when he got that handwritten notice, or that he needed to go to the bankruptcy court and say, hey, they're proceeding ahead in violation of the stay. He did not do that.
I understand the argument.
Okay,
incorrect.
Thank you, Judge.
May I?
Yes, sir.
Notice was provided to the bankruptcy court immediately with a copy of the document, and Mr. Cochran has a copy of it because it was all submitted to the JP court. This lying needs to end. And
Mr. Goad,
we will.
Mr. Goad, Mr.
Yes,
Goad.
he knew all about it.
Mr. Goad, here's my problem. I haven't looked at all the documents, but it seems to me that the JP court hearing was far after the bankruptcy was dismissed.
Yes.
Well, I was not allowed to participate in the JP court hearing. So we'll move on to that a little bit later.
Well, I understand that, but my point is this. You're saying that he knows about it, but he knows about it at a hearing that occurred after the dismissal of the bankruptcy.
Can you restate that, Your Honor?
Sure. You're saying that he found out about it because he was given a copy at the hearing at the JP court.
No, incorrect. He knew it beforehand, and he admitted.
How did he know it beforehand? And who said? How did he know it beforehand? And what is your argument that he knew it beforehand?
I don't have that in front of me, and I can't remember.
Okay.
But his billing statement to the court when he submitted his fees for the hearing included research of the bankruptcy case. He admitted in his own documents and his billing statements that he did this work. He knew this thing, everybody knows about this case. This has been a pretty big case. It's been to the U.S. Supreme Court. It's been to half a dozen courts from California to Texas. Everybody knows about this. That's why a lot of people wouldn't bid on this property.
I'm understanding that a lot of people might have known about the case, but the question I have before the court is, has it been proven in this record? That's what I'm concerned about. Did you prove in this record that happened?
Billing, if we pull, can he pull his first billing?
If you pull the billing statement, unless the billing statement says I was researching this and found this information, I don't know that proves it either.
It does. It says he's asking the court to award him attorney's fees
Mr.
for the bankruptcy background.
You've made your point that is in fact in the billing statement. Since that's part of the record, all you have said is that that's a part of the record, and the court, me, should in fact look at the record in his billing statements to ascertain whether or not he knew about it or should have known about it. But that record is in the evidence, and that's your argument. I understand it.
I would also like to, since this issue came up, I would also like to supplement, give me some time to look through documents. I have 3 banker boxes here, and that's just part of the record of just the hearings on this whole shenanigans. So
you're having a hearing today, Mr. Goad. That's not going to happen. So okay, that request is denied. What's the next thing you got, Mr. Cochran?
I'll pass the witness. I'm finished with my questioning.
All right. Do you have any questions of Mr. Smith? Mr. Goad?
I do, but so 3's not admitted yet. We didn't.
No, 3 is admitted.
Oh, 3 is admitted.
Yes, sir, it is.
And I objected to that one because I was not allowed. Did I reiterate that I
Everything that you have, Mr.
provided.
Goad, I'm going to remind you one more time. If you've opened your mouth and spoken into the thing that you're speaking into, which is your phone, my court reporter has heard it. If she's heard it, it's on record. You don't have to ask the question again. If you're talking,
Well, I don't
it's
know.
on the record.
I told you, Your Honor, I have a memory issue that's very bad. I just want to make
That's
sure 'cause
fine.
I don't have a
And that's why I'm reminding you. If you're talking,
Yeah, I
get
just, okay, I just want to object to that because there was no 736 hearing in accordance with the state constitution of Texas. It did not take place.
I
There was
understand that.
motion, a verified motion.
Mr.
that
Goad,
requires
I've
the
understood
state
that.
to
You
have
said
hearing.
it, Mr. Goad, I've understood it.
Okay,
And if you're going to,
Okay.
it'd be difficult for you to challenge what I've heard, given your memory issues, wouldn't it?
all right. Now, so I've objected to each one of them.
You have, and I've overruled those objections, and they are admitted.
Okay. Now, for Mr. Smith. Mr. Smith, did you, what date or time did you learn Mr. Goad was in bankruptcy?
I don't know that date or time.
Was it before the hearing, the JP hearing?
I believe that's why we held off on doing the JP hearing, but I don't know offhand.
Was it a week before the JP hearing?
I honestly don't know.
Was it 2 weeks before the JP hearing?
I don't know that answer. It was before the JP hearing, but I don't know that answer.
Would you have that available in an email or communication with your attorney?
I believe so, but I don't know that.
Do you have your computer or anything with you that would show that, your cell phone that might have that email on it?
I'd have to go through and check.
Do you have that available to you at this time?
I do have my computer with me, yes.
If we were to take a small break here, would you be able to identify that date?
I don't know that I would be able to in the email at this moment.
Well, we're not going to have a small date,
Yeah.
a small break here. You've made your point. It either did or it didn't. And he said he can't recall. And we're not taking a small break.
He has the evidence there for us, Your Honor.
I heard it, Mr.
Okay.
Goad. I understand that you recognize, I recognize that you don't like what I'm doing or how I'm ruling. I get it. But those are the rulings.
All right. Mr. Smith, did anyone assist you in finding a value of this home? Anyone that lives or works in New Braunfels?
Judge, I'm going to object to relevancy. Texas law is clear that the owner of a property can testify to its value.
Sustain the objection.
Mr. Smith, were you aware this home was uninhabited for quite some time because of toxic mold?
No, sir.
So you've never heard that this home was vacated because of toxic mold?
No, after I purchased it, I drove by, saw that it looked like it was occupied, and that's all I know. The lawn was well taken care of, so I figured someone lived there.
Have you read any of the court documents Mr. Goad's filed with the courts?
Not concerning toxic mold. This is the first time I've heard anything such as that.
So you never read the JP court documents or the
Judge, I hate to interrupt, but I just have to object to relevancy on all of this.
Mr. Goad, is there a point here somewhere?
Absolutely.
What is it?
The home, he's attempting to use rental values of a home that is readily marketable for tenancy. This home, and it's in the court documents. It's filed with the JP court, filed with the county court. I don't know if it was one or both, but it's filed there with even pictures of the toxic mold. I had to move out of the home for 2 years.
I'm going to sustain the objection.
I believe you remediated that mold, correct? You fixed it.
No, it has to be certified. And you
Right.
have a copy of the letter that has to be certified to be free of mold.
So I'll
And that's what
resubmit
caused
my-
me to get sick again.
Well,
my
that,
objection.
Mr. Hold on. Everybody stop talking, because I'm talking. All right, let's just hold for a second. Mr. Goad, that goes to whether or not the rental value is a correct one. You've made your point. You can move on.
I'm reading notes here, sir. Just a moment.
Madam Court Reporter, how long have we been in this hearing?
What was that question for?
My court reporter.
Oh, sorry.
Yes, sir. Yes, ma'am.
No more questions for Mr. Smith.
All right. How long have we been in the hearing? I can't hear you. What?
It started at 9:08.
That's what I needed to know. Thank you very much. All right, let's proceed.
Judge, I'd like to testify as to attorney's fees.
Yes,
File
sir.
a Second amended declaration.
Yeah, I swore you in earlier. Did I swear him?
Yes, I raised my arm.
Oh, Madam Court Reporter, do you remember if I swore him? Yeah, okay. We're good. Go ahead, sir.
I filed a second amended declaration with my billing records. And that brought the fees at that point up through the end of October. And that was $6,893. There was a fee reduction. We bill in quarter-hour increments. Then we look at the billing statement and make adjustments for tasks that didn't take as long. So to skip to the end, well, let me say that I've been a Texas lawyer for 50 years, practiced civil litigation, real estate, probate, various civil cases in Bexar County, surrounding counties, Dallas, Houston, Austin, and the Valley. And I can say that a $275 an hour fee is very reasonable, particularly for litigation work. And that the fees that were charged in this case are reasonable and necessary, and probably lower than fees charged for similar work by Texas lawyers practicing in Comal and Travis counties. So my total hours through trial, I've added an hour for trial and a half hour for preparation this month, 24.5 hours through trial. And the fees are $6,758.25. I also want to testify to appellate fees in the event this is appealed. And I believe that a $1,500 fee is reasonable if a motion for new trial is filed or to set aside the judgment. $4,500 in fees if it's appealed to the Third Court of Appeals, and $9,000 if appealed to the Texas Supreme Court. Those hours for those fees are 5.5 for the motion for new trial, 16 hours for Court of Appeals, and 33 hours if it's in the Supreme Court. And that concludes our presentation. I do have an argument to make on the plaintiff's right to obtain immediate possession in this case.
Hold on a second. We've got to go through Mr.
Yes, certainly.
Mr. Goad's side of this thing. Mr. Goad?
I just found his fees under Exhibit A dated 6/6/2023. Is that the improper one? I'm trying to find all of these.
Judge, I hate to cut Mr. Goad off, but I just don't understand why we should have to sit through his trying to do discovery or find documents that may help his case. This case has been pending since he filed his appeal. back in July. And unless he's got something relevant now, I'd like to have us proceed.
I understand that's your desire. My question is, what is it Mr. Goad is I'm trying to get at? What is it, Mr. Goad, that you think you found? And what does it say? If you
It's not
found
what
it?
I think I found, Your Honor. As I've explained to the court, the medications I take, as you noticed in my first hearing, I couldn't even remember my objection.
Mr. Goad, my question is, what did you find? And read it
I have
into
it.
the record.
I'm looking to see, I'm trying to refer to, I'm
You said you
referencing
found
what
it.
he just did, but just this conversation now, I'm lost to where I was at.
Mr. Goad, I need you to read into the record what you think you found.
Well,
Judge,
I'm trying
maybe I
to
can-
find to make sure.
Maybe I can help, Judge.
Sure.
I've got my billing records for June, and on 6/1, I read
6/1 of what year, sir?
this year, 6/1/2023,
Okay.
became aware of the bankruptcy case, reviewed the docket sheet, and I had a telephone conference with the bankruptcy trustee's lawyer. And received on the 15th of June, the bankruptcy dismissal order from bank counsel. And our hearing on the eviction was on June 26, 2023. And I informed the JP court at that time that there had been a bankruptcy. It was filed too late to stop the sale, but
Correction, it was not.
It was dismissed prior to proceeding with a hearing to evict Mr.
Yes, I understand that. Mr. Goad, what?
I'd like to correct that. It's untrue. Case all show that was filed the same day. Even though it's filed after the case, everything ends right there. They cannot transfer the property. They cannot accept Mr. Smith's money. It ends it.
Mr.
Even
Goad.
if it was done shortly thereafter.
Mr. Goad, if I've heard nothing else in this entire hearing, this is I've heard your argument. It is pretty clear to me that you think and why you think that. And even if it wasn't clear to me, I have a record of what it is. So I'm pretty sure that I know exactly what the argument is because you have repeated it 6 or 7 times now.
And Mr. Cochran has repeated it multiple times that I've done the opposite of it. So, okay. Anyway, no, I just wanted to review his billing statements here, and I have.
Okay, move forward then.
All right. What's next?
You tell me. This is your side of the case. Do you have anything you want
I'd like to,
that
now
you
I
have
can
to,
present my
wait on, listen to me for a second. Do you have anything you want to raise that you have not raised, or any testimony you haven't already given to the court that you would want to say here now?
Absolutely.
Then you should do so.
Okay, first of all, normally I in the past, I've been to a few hearings in the last 50 years. I'm asked if I'm ready or whatever it is, and I wasn't ready to begin with this. I mentioned to the court before I wanted to provide a writ of mandamus. Now I want to tell you why I wanted to provide a writ of mandamus.
I don't need to know why, and I don't need to hear why.
You don't want to know the law of why I should be granted a writ, or why I should petition the court, or why?
Well, because I wouldn't grant. Okay, here's the problem that you have. If you're getting a writ of mandamus against me, then that's against me, and I don't.
Well, that's an assumption. Let's not assume anything.
Well, who's the writ of mandamus against?
Against the JP court.
That's not going to happen either, because this is a trial de novo. It's as if the JP never occurred anyway. I'm not going to give a mandamus.
That's right, and that's the reason why the statute says I can have it, because there's no other there. But I have to read the case law. I have to read it. That
Mr. Goad, this is a trial de novo. As I understand how this works, and I've been here a little bit myself, this is not something you get to do to the JP court. I'm not mandamusing the JP court. If that's what you're requesting, that request is denied.
Okay, it's denied, but I would, you know, I'm not given an opportunity to present this.
Mr. Goad, I don't believe I have the authority to do so. It's denied. And no, you're not going to have to say anything more
Well,
about
of
it.
course you
You're
don't
asking me
unless
to
I
do.
read the statute.
Mr. Goad, stop talking over me. When I'm talking, stop talking. If there's a writ of mandamus you think I can give to that court, I don't believe that I can. And even if I could, I don't know that I would. Here's the problem that you have. You've asked for a writ of mandamus, that's denied.
You know, I really like this about Texas.
Mr. Goad, you're not going to sit up here and talk about the courts of Texas, and that's not something that you get to do here either. You don't like me, and that's immediately apparent. It's all over the record.
Oh, it has nothing to do with like, sir. But that's exactly wrong. It has nothing to do with
Mr.
like.
Goad, I don't think it is wrong, and my thoughts are not something that are subject to your whim. So would you please just tell me what is next you want to have as evidence in this case?
I have to go just a second. I have to put this away since we're not going to be able to cite what the court allows or doesn't allow. Here's just a second here. Okay, I'd like to, for the record, I'd like to say that yesterday I had planned to submit the writ and my evidence, and at around 3 o'clock or shortly before then, the internet went down. I couldn't submit. I spent approximately 2 hours on the phone trying to get everything up and going, and that's why I'm on a phone now. I do not use a landline. I do not use a landline connected internet. I use a mobile hotspot is what they call it. That's what I was trying to come up with through AT&T. And this happened to me once before a couple of months ago where their computer system shut me down. Let me check. I just got a beep. Okay. I thought it was my battery. And so I was unable to get the writ in or my evidence. And the writ can only be done in a justice court. I was rejected by the Third Court of Appeals because I didn't have standing there. The only place I can perfect the writ is through your court. That's the only avenue I have for that. That's why I was.
When you say, you just said that, what I just heard you say was that it could only be done through a justice court, correct?
Affirmative.
This is not a justice court.
Appeals, sir?
This is a this is a county court at law. It's not a justice court.
Okay, you'll have to excuse me, my memory here, okay? A JP court, a writ of mandamus cannot be brought against a JP court by the Third Court of Appeals where I submitted it. They rejected it and sent it back to me, and it's in the record. So I have to go to a county court, your court. Now, when we transferred to the county court in Comal County, I remember in the past reading about law that if I engage that court any further than necessary to get the case moved, that I'm accepting its venue. So I did not pursue the writ of in the county court in Comal County. I was planning to do it in your court.
Mr. Goad, I understand what you're saying. I don't believe that a writ of mandamus is appropriate here. And I understand the argument you just raised, which you have done to me. I get it. That's fine. What else is next?
Okay, I got to add one more sentence to this. Your Honor, you have no clue to what I've put together. I've worked on this since the motion for summary judgment came about. It rechanged the picture. So I worked for the writ of mandamus on due process. And unless you see what I have, you have no clue what I've got. You're just saying, no, I'm not going to do it no matter what. And that is not what due process is about. So I and if you take that personally, I apologize.
I'm not taking it personally. I just think you're wrong. Mr.
Okay, you don't know if I'm wrong until you read what I've got. Number
Well,
one,
that
I
may be
bought this-
true, but I
I
don't
bought
believe
this
that to be the
home
case.
for
Mr.
cash.
Goad, I'm not going to sit here and fuss with
Yeah.
you. We have been at this hearing an
Right,
hour.
okay,
Do you have
All
any
right.
more information
Now-
that you would like to give with regard to whether or not this writ of possession should be granted?
right. Now, I'm gonna go on to that, but I'm gonna go back to his exhibits, because his exhibits.
No, you're not
are
going back
much-
to his exhibits. That conversation is now closed. You need to go forward.
Well, I'm going forward, but because I couldn't.
you
get
are
my
talking
exhibits,
about
then
the
they show
exhibits- Mr. Goad, I'm not going to keep fussing about this. This hearing is almost over because you keep talking about things that I've asked you not to talk about. And whether or not you do want to talk about them or don't want to talk to them about them is up to you. But once I've ruled, I've ruled. And if you don't like that, that's fine. There are avenues to do that, which you have availed yourself of
So-
before.
Let me understand this. Okay, for example, his exhibit 2 is a transfer of lien. Now, if my exhibits would have got, may I finish my sentence, please?
No, you're not. We're not moving that's not moving forward. I've asked you to stop that. We are not going to talk about his exhibits. You've told me that
I'm
your
using
exhibits
it
didn't
as-
get here. Mr. Goad,
You know,
These
Your
are-
Honor, Your Honor, may I finish my goddamn sentence?
all right, this hearing is now over. Mr.
That's
Goad,
right, because you interrupt me, and when I interrupt you, you cry and scream like a baby. So just make your fucking ruling and let's end it.
I'm not going to make my ruling. I had already determined I was taking this case under advisement so that I could review the documents you, in fact, have given to the court like I'm supposed to do. But the hearing is now over. Thank you all very much. I will get back to you as soon as I can.